Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content. And today will be the day I earn that subscription. For today's content, we are going to be going through Amber Heard's motions in limine. That is, motions to limit, as the name suggests, things she didn't want you to know, as detailed by her own court documents. So we're going to go through this in some sort of detail. There's a lot of stuff here. There's 1,000 pages between the motions and the exhibits. So obviously we're going to read some of this in full and skim some of it, but we're going to try to do as much of this as possible. So buckle in, friends. This is going to be a long stream. It may involve me taking breaks because we might be here a while, but that's okay. That's how we're going to roll, because we roll deep here on the Uncivil Law. Fantastic. So let's go ahead and pull those things up, which I need to do because I accidentally closed them. Where are they? Where did I put them? Talk amongst yourselves. Don't worry, we've got plenty of stuff to talk about. Plaintiff's motion in limine, defendant's motion in limine. That's what we want. We want defendant's motion in limine. Great. There we go. That's what we need. Now we just need to make sure it looks nice in the window. It looks great in the window. Fantastic. See, it didn't take very long at all. Also, I think we need the hat. Yeah. Okay, so this is a motion in limine. All right, so as we've discussed, of course, at time to time, the trial's not just what you see. Trials are never just what you see. There's a lot of motion practice. There's a lot of papers that are filed in court before you ever get to trial. These can be motions to suppress in a criminal case. They can be motions to exclude witnesses for any number of reasons. There are motions to prevent one of the parties from doing something, for example, by referring to you in a particular way. One of the motions in limine we saw, for example, in the Rittenhouse trial was to prevent the use of the word victim, because the word victim perhaps has a connotation that's prejudicial. So that's the kind of thing, like excluding the use of a particular word, excluding particular lines of questioning. It can be to restrict, it can be to exclude an expert witness because they're not qualified. It can be to constrict or restrict an expert witness to particular questions or particular fields of expertise. It can be to prevent particular lines of questioning into particular matters because they violate the rules of evidence or other problems, right? So, you know, a lot of this is basically objections before you ever get into court. Motions in limine, if you want a good way to frame what a motion in limine is, they're basically objections you can predict in advance. That's what they essentially are. They're objections you can predict in advance. That's a good way of putting it. And so, to the extent possible, you bring everything up beforehand, so that you don't have to bring it up at trial and litigate everything during the trial while the jury's there. Like, if you can anticipate it in advance, why not deal with it in advance? So a motion in limine is kind of like an objection you can see coming, and so you do it in written form before the trial ever happens. That's a good way of putting it. All right, so what do we have here? All right, so here we have a cover sheet, which, as we can see, was initially confidential, under seal. Less confidential now with the under seal part. So comes now the Amber Heard by counsel and moves this court to exclude certain matters from this trial. The grounds for motion are set forth in an accompanying memorandum, which we will read. So this is just the highlights. This is 7 pages, just the highlights, the top line if you want. And then we go into the reasoning. So what statements do we want excluded? The statement from the headline of the Washington Post should be excluded and redacted. Any evidence, testimony, or allegations of criminal conduct against Ms. Heard should be excluded based on Virginia rules of evidence and relevance, which relevance is also a rule of evidence, but okay. Evidence respecting either Amber Heard or Ms. Depp's pledges or donations to charity should be excluded. Evidence of Amber Heard's pledges and donations to charity should be excluded. Evidence of Mr. Depp's charity donation of money or time should be excluded. Yeah, we don't want to have any of the pesky details about the money that she did or did not provide to charity. Okay. Mr. Depp should be precluded from introducing any evidence on subject to which attorney-client or work product privilege was asserted. That doesn't even really make sense on fundamental principles. If Depp introduces it, then he waives privilege as to it, which is the thing that you're trying to accomplish in the first place. So I don't know why you'd want that, but okay. Ms. Heard should be permitted to designate testimony from Tracy Jacobs in 2 other litigations filed by Mr. Depp, where Mr. Depp was represented by counsel and where depositions were produced too late for Ms. Heard to elicit from Ms. Jacobs. So we'd like these other depositions in these other cases offered in this case. Evidence following irrelevant personal matters should be excluded. The plaintiff should not be allowed to introduce evidence of irrelevant personal matters because such matters are not probative of any material fact, including whether Depp ever assaulted Heard. I mean, you're kind of assuming your premise there in your question. You shouldn't be allowed to introduce irrelevant personal matters because they're irrelevant. You're kind of assuming your own premise there, but that's okay. Plaintiffs should not be allowed to introduce evidence relating to irrelevant personal matters because any probative value is overweighed by unfair prejudice. Well, if it's irrelevant, then you can just exclude it based on relevancy. Okay. Prior irrelevant litigation legal matters, references to and characterizations of a 2018 arbitration decision should be excluded. Counsel's characterizations of the UK judgment should be precluded. Okay. Allegations of Amber Heard abusing anyone and claims of Mr. Depp not abusing other individuals should be excluded. This kind of goes to their respective characters. This is a bit of a problem. We'd like to exclude Mr. Depp's claims Amber Heard abused anyone and also exclude claims that Depp did not abuse anyone beside Heard. Yeah, it kind of goes a little bit to their character and also goes a little bit to the nature of any physical alteration between them. So these might be prior bad acts, but they are relevant to the charge in question because it goes to the essential element of their character, their temperament for violence, and whether or not they use violence. And so these past acts become relevant because it goes to essential charges or essential elements. The documents produced by Depp as whatever should be struck from an inadmissible trial. I guess we'll get to that in some detail later. Mr. Depp's expert witnesses and their testimony should be excluded pursuant to the Crane Doctrine. Exciting. Dr. Shaw should be excluded from providing any expert testimony because the Goldwater Rule is not applicable to litigants. Okay. Dr. Shaw is permitted from commenting on the medical records in this case. Maybe we'll get into that as to why. Dr. Kipper should be excluded from providing any expert testimony. Plaintiffs' so-called non-retained experts should be precluded from presenting testimony as experts, and plaintiffs should not be permitted to refer to them as experts at any time of the trial. Mr. Newmester's testimony should be excluded. Dr. Curry's testimony should be limited. Mr. Newmester's testimony on the impact of the jury verdict in Mr. Depp's favor on his career and reputation should be excluded. This is all kind of par for the course, by the way, in some senses. This is like basically normal litigation practice. So, this is what you want to do as a lawyer. You want to make your client's case as good as possible and their case as bad as possible. So you want to bring in everything that you think that's good for you, and you want to exclude everything that you think that's bad for them. And they're exactly the other way around. Of course they are. This is the nature of the adversarial system. And we think that it will all work itself out, because if you're advocating as hard as you are, and I'm advocating as hard as I am, and we're incentivized to work for our causes, then we will be able to figure out what's really true somewhere in between of it is sort of the idea, which, okay. Motions in limine respecting Mr. Depp's witness list. Mr. Depp improperly included witnesses in his witness list for whom he's provided inadequate contact information. And there's a whole list of people. Okay. Mr. Depp improperly identified witnesses testify by multiple means at trial in violation of the audio-video consent order. Dr. Curry's medical exam of Heard should not be referred to as an independent medical exam or administered pursuant to a court order. Okay. The jury should be instructed to ignore any redactions in medical and mental health records and not give the redactions any significance or speculate as to what's been deleted. That sounds like a very appropriate thing to ask for, to be quite honest. Mr. Depp's trial exhibits containing partial audio recordings contained by counsel should be excluded. Counsel should be precluded from referencing or characterizing pleadings, motion practice, discovery matters and rulings, or deposition issues, disputes, or conduct in the presence of a jury. Evidence regarding Paul Barris and any investigation should be excluded. Any references of a pretend punch by an unknown person on an alleged video, which does not exist, should be excluded. That's a lot of qualifiers there. I'm not exactly 100% sure what we're talking about. The alleged video does not exist. Plaintiffs should not be allowed to introduce testimony respecting a non-existent pretend punch video because it involves a non-party and is not probative of any material fact, including whether Depp ever assaulted Amber Heard. Testimony about the non-existent pretend punch video is inadmissible hearsay within hearsay. Okay. Plaintiffs should not be allowed to introduce evidence of the non-existent pretend punch video because any probative value is substantially outweighed by danger of unfair prejudice or likelihood of confusion. Okie doke. Use of declarations, UK witness statements, or prior testimony should be excluded unless properly used as impeachment evidence or not objected to in depositions as part of the deposition designation. The testimony and prior statements and declarations of Jennifer Howell should be excluded in their entirety. All correspondence regarding any Warner Brothers stipulation or declaration and their contents should be excluded for evidence. I mean, those might go to damages in some way, so, okay. Mr. Depp should be precluded from offering testimony of Christian Carino's first day of deposition. Mr. Depp should be precluded from introducing or referencing deposition questions Eric George did not answer based on attorney-client privilege objections. Mr. Depp should be precluded from references and characterizations of Ms. Heard's counsel or prior motions and court rulings in this case. All references to the legal process utilized by Ms. Heard to obtain the California Domestic Violence Temporary Restraining Order should be excluded. Mr. Depp should limit the op-ed in asserting any liability or damages against Ms. Heard under the complaint, limited to the op-ed, which that's a perfectly reasonable thing to ask for. I mean, that's the thing he's suing over, so that's the thing that the damages should be based on. That makes sense. Evidence of who's paying attorney's fees should be excluded, and any reference or suggestion that Ms. Heard is having an army or many attorneys on the case. Plaintiff should not be allowed to introduce evidence of who's paying for legal fees because it's not probative in any material fact, including whether Depp ever assaulted her. Might be probative as to whether she's lying on the stand, though, but okay. Plaintiff should not be allowed to introduce evidence relating to who is paying each side legal bills because the probative value is substantially outweighed by danger of unfair prejudice, and all evidence of settlement communications or documents relating to mediation should be excluded. And then signed by Elaine Bredoff. Okay, well, that was interesting, but those were just the top line. What is our rationale for those things? No problem. I've got 995 pages to explain it to you. Seriously. So we're going to try to go through some of this, but not all of it because, I don't have the patience to read 995 pages, and I'm not sure anyone would watch. Maybe if the super chats come in, there's something. We'll see how much we read. I can be bribed is basically the proposition we're going for. All right. So here we have in the Circuit Court of Fairfax County, the memorandum in support of the motion to eliminate. So we just read the motion. That was the top line. Now we have to provide our rationale. And we got 995 pages of rationale. Okay. So we have the table of contents that we go through. Table of contents. And then we've got a whole bunch of attachments. So this is where most of the 995 pages are coming from. So we will read most of the 70 pages of the motion. And then we will probably skim the remaining 925 pages. Because what the 925 pages is all the things from all the things we want to exclude. So the Australian transcript, the Australian Crimes Act, Whitney's deposition transcript, various transcripts from various people, hearing transcripts, supplemental motions, choose motions, emails for in-camera restrictions, Heard's motions, Shaw's deposition order, an APA ethics opinion. Okay. Kipper deposition transcript, disclosure order, articles, emails, so forth and so on. All right. Let's go through the relevant legal standards. How many pages does a super chat buy? That's a good question. I can turn this into a real big grift, which I'm not necessarily opposed to. How much should I charge for a page? Let's say I'll do, trying to decide if $1 a page is too little. I mean, that's $1,000, but also it's 1,000 pages. Let's start with $2 a page and go from there. How much to not read large chunks? If you don't want me to read stuff, I guess you can counter it. So I will accept your super chats also in the same increments to not read things. So you guys can fight each other with super chats. I'm down for that. So if you want me to read something, $2 a page. If you don't want me to read something, $2 a page. And just let me know which way, and we'll try to keep count accordingly. Can you pick which part you want to fund? Absolutely. Yeah, you can absolutely pick which part you want to fund. That'd be fine. Virginia Rule of Evidence defines relevant evidence as tending to make the existence of any fact in issue more probable or less probable than it would be without evidence. Evidence is relevant if it tends to prove or disprove a material fact. Evidence that is not relevant is not admissible. In addition, even if evidence could be relevant, it should be excluded in certain circumstances. The Virginia Rule of Evidence provides that relevant evidence may be excluded if the probative value of the evidence is substantially outweighed by danger of unfair prejudice or its likelihood of confusing or misleading the trier of the act. Evidence which is inflammatory must be weighed against tendency to offer evidence to produce passion and prejudice out of proportion to probative value. Unfair prejudice involves a genuine risk that emotions of the jury will be excited to rational behavior, and this risk is disproportionate to probative value of the offered evidence. Okay. The statement from the headline should be excluded. In ruling on the demurrer, which is a motion to exclude, basically, it's a motion to strike, former Chief Judge White, New Zealand gives me $2. Do page 60. Well, you gave me New Zealand $2, so you still owe me 75 cents. In ruling on the demurrer, former Chief Judge White held that 3 statements from the op-ed may be potentially defamatory and therefore survive the demurrer. At the demurrer stage, all allegations of the claim are taken as true, and Ms. Depp asserts Ms. Heard made the statements in the original headline of the op-ed. Amber Heard, I spoke up against sexual abuse and faced our culture's wrath. That has to change. There's only one instance of Ms. Heard referring to the essay, and that was in the body of the op-ed. Like many women, I've been harassed and essayed by the time I was of college age. The court did not find this statement to be an actual statement in Mr. Depp's complaint. After all the evidence had been taken in the case, Mr. Depp, who bears the burden of proof, $2 from E.E. Caroline, page 666. Okay, let's take a look. Mr. Depp, what would you like to do, Amber? Miss Heard, inaudible. Mr. Depp, Miss Heard, inaudible. Security, safety, inaudible. I want them back. The ones I've destroyed and the ones you've destroyed. The ones we've destroyed. I want to know the marriage is sacred. I want to know. Mr. Depp, the marriage is sacred. Miss Heard, I want a few things. I want to make promises to each other. I want promises because I need the safety. I need the security. I need the safety back. I need to feel safe with you. Inaudible. Through phrases, and sometimes inaudible, feel safe. Inaudible, that song. Mr. Depp, misheard. You have stripped me down and shaved my head. And I've done the same to you, probably to you, you would say, right? And now we're both here. And I want some of the safety back. I want to make the commitment again. I want to. And I want to have reason to honor it, you know? This concludes page 666. Back to page 11. After all the evidence had been taken in this case, Mr. Depp, who bears the burden of proof, cannot establish through any evidence that Miss Heard made the statements in the headline. Miss Heard testified that she did not write the headline and did not see it prior to publication. By Ben Chu. Now let's go through this. The version, the percentage of the op-ed that's entitled, Amber Heard, I spoke up against sexual violence and faced our culture's wrath that has to change. What are you referring to there? Question, who wrote that title? Answer, I'm not sure. Question, but you approved the title, correct? Answer, I never saw a title before it was printed or went to press as far as I can recall. So 499 says, then do the next page, and then do the next page, then the next page, then Luke's page. Okay. Like, there's no point in honoring it if you think the other one's just going to effing take off. Throw the ring at you, you know? There's no point in keeping a boundary if you think you're going to be hit, or you think you just effing run, you know? Either way. For this to work, I want to make promises and keep them to each other. And I want to get help to know how we fight. I mean, to get help fighting. I think it's always bigger issues. And we don't have the ability to bring it up safely with one another. I want you to always be honest with me. And I want to be able to take criticism and help myself be someone that fits your life in the same way I want you to help fit my life. You know, I was just saying in Brazil about coming back for the test. And I want to be as important as you are to me. And sometimes it's inconvenient to fly when you want to leave. So I don't like flying in the middle of the night, but I do it, you know? Sometimes it's inconvenient. I'm missing work or I'm missing this. I mean, look at me. I haven't worked since February. Mr. Depp, inaudible. Miss Heard, depressed, inaudible. Mr. Depp, 5 movies coming out. Oh no, you have, inaudible. Miss Heard, I have just one, Danish Girl. The thing is it's inconvenient, but I do it because I love you, and I want to do it. I want to make my life fit into yours. What I'm saying on the plane was just that, hey, can you motivate me to make this not stressful for me? And that didn't happen. And then when the plane was 2.5 hours late, which was out of your control, and the car was 2 hours late, out of your control, it really, I barely got there in time, and I didn't have time to shower, do any of the things that were comfortable, that needed to feel comfortable and okay, calm and safe. I didn't have that. Not. And then the other page was page 69. And her testimony is completely based on hearsay, and hearsay within hearsay, and it's irrelevant or more unfairly prejudicial than probative. Ms. Howell's testimony did not satisfy any exception to the hearsay rule under Rule 2-803, and should therefore be excluded from evidence pursuant to Rules 2-802 and 2-805. Plaintiff has designated portions of Ms. Howell's testimony where she described Whitney's testimony, Ms. Heard's sister, speaking on the phone in another room with an unknown person, and then Whitney telling her that the person had said Amber had cut off plaintiff's finger. These allegations based on hearsay, and also described in Ms. Howell's declaration, submitted in this case, and her witness statement submitted in the UK litigation, whereas plaintiff has pointed out different evidentiary rules apply. This game of telephone also constitutes hearsay within hearsay, under Rule 2-805, and there are no exceptions to either alleged statement from the unknown caller or Whitney's statements. The testimony should therefore be excluded. Plaintiff has designated another portion of Whitney's testimony of Miss Howe's testimony, where she describes an incident involving Amber throwing a glass of wine at her sister Whitney. Miss Howe has also testified that Whitney told her Amber beat her throughout her whole life. This account is based solely on an alleged conversation she had with Whitney and is once again based on pure hearsay. Miss Howe never witnessed any abuse by Heard against anyone. In addition, evidence of Heard's alleged abuse of her sister is completely irrelevant to whether Heard suffered any abuse by Depp, and by any means more prejudicial, more probative, and should be excluded relevant to Rule 2402 and 2403. Ms. Howe's statement, declaration, testimony are also tales of how defendant has pushed. Thus concludes page 69. Back to page 12. This is fun. I'm enjoying this, by the way. This is fun. As long as it keeps being fun, we'll keep going. Moreover, the evidence is clear that the ACL submitted the article to the Washington Post publication without any headline. At 4:23 p.m. on December the 18th of 2018, the op-ed was sent back to the ACLU from the Washington Post editors for finalization without a headline. It was approved, still without a headline, at 5:54 p.m. and published online approximately 4 minutes later. There's absolutely no evidence Amber Heard drafted, was aware of, approved of, or even commented about the headline to the op-ed with the Washington Post at any time, let alone in the 4-minute window from the time of approval to the time of publication. In addition, the ACO corporate designee testified the Washington Post drafted the title of the article and was not approved by the Amber or the ACLU. Yeah, that's where the republication comes and bites her in the ass. By Mr. Chu, directing your attention to the title, Amber Heard, I spoke up against sexual abuse and faced our culture's wrath. That has to change. Who came up with the title? Based on my investigation, I was not aware of any. I was not aware the ACO had any role in writing the names of the op-ed piece, and my understanding of how op-ed pieces work is that the media, in this case the Washington Post, would have drafted the name of, the title of the op-ed, and then not the person who wrote the op-ed. That is pretty typical, incidentally, that yes, usually it's the editor who writes the title. Did the Washington Post seek the ACLU or Ms. Heard's approval of the title? I believe the answer to that is no. There's nothing in evidence that shows that they reached out to us to do that, and it's inconsistent with my understanding of how news outlets usually do not ask for permission of the author for when they come up with the title. That is generally my understanding as well, to be sure. There's no evidence Mr. Depp can proffer that which would establish Ms. Heard's draft of the title of the op-ed was aware of the publication or approved of it. In the first instance, you're right, but the whole republication. Indeed, the only evidence she did not. The burden of proof is on Depp, and they were unable to present any evidence to support their position. Therefore, the headline should not be considered by the jury. Yeah, but the republication, though. Any evidence, testimony, or allegation of criminal conduct against Ms. Heard should be excluded based on Virginia rules of evidence. Throughout the case and explained below, Mr. Depp has repeatedly made various allegations respecting conduct of Ms. Heard to prove she's a liar and claimed that she's been convicted of or is engaged in criminal conduct, and has repeatedly referenced an attempt to insert them into this case, as if they establish Ms. Heard must be lying about the issues at hand about the abuse. However, in Virginia, only the fact that the party in civil case has previously been convicted of a felony or a misdemeanor involving moral turpitude, and the number of such convictions may be elicited during examination. In no event may the details of the prior convictions be elicited unless offered to rebut other evidence concerning prior convictions. Despite Virginia's clear rules on this type of evidence, Depp has attempted to obtain discovery from matters far outside the parameters of the rule to harass Ms. Heard, including serving extensive third-party discovery. First, Depp seeks to introduce evidence relating to an arrest at the Seattle Tacoma in King County, Washington in 2009, where Ms. Heard was arrested and quickly released, and charges assault. Ms. Heard grabbed her partner's wrist to get her attention when the rental bus was leaving, were dropped, and the arrest later was later expunged. It's undisputed no criminal charges were ever brought against Ms. Heard in King County, let alone resulting in conviction. Therefore, evidence, testimony, or references to this arrest or underlying alleged conduct are inadmissible pursuant to law, and also the details underlying these charges may not be elicited by Mr. Depp at trial. This information is also not relevant to the issues at this case, and the risk of prejudice far outweighs the probative rules. Second, Depp also seeks to introduce evidence relating to an incident involving Miss Heard's custom declaration in 2015, when she and Depp brought their dogs into Australia while Depp was filming Pirates 5, again to suggest that Depp has a criminal record and has been found to be dishonest by the court. Well, not yet, but that's coming. As with the King County matter, there's been no conviction recorded because the Australian court instead discharged the person without proceeding to conviction. Yeah, Australia is having second thoughts about that one. Relatedly, testimony emerged in the UK trial where a third-party witness, an employee of Depp, claimed that Heard asked him to make false statements in the Australian proceeding, but he refused. Miss Heard has denied this, but since she's never had a conviction recorded in Australia, the testimony falsely accusing her of attempting to manufacture testimony is also inadmissible. Such evidence should be excluded as irrelevant to the issues at trial, and any possible evidence is outweighed. The notion that the notion that signing an airport form relating to immunization of Mr. Depp and Miss Heard's dogs suggests she's lying about being abused is untenable. Oh no, a liar in one thing, a liar in everything, man. That's definitely a somewhat tenable proposition. Third, the UK trial included testimony relating to Savannah McMillan, an assistant to Miss Heard while she was filming in the UK, and the status of her employment relationship with Heard in the United States. Let's see, where was I? Yeah, okay. Miss Heard provided a letter to the Immigration Department in support of Miss McMillan in 2014 after Miss McMillan had been stopped and questioned at an airport. There were never any charges brought against Miss McMillan or Miss Heard, so these allegations that Miss Heard lied to immigration authorities about the true status of Miss McMillan's employment status in the U.S. are not admissible and should be excluded under the rule. Such evidence is also completely irrelevant to the issues at trial. Whether Miss Heard allegedly lied to immigration authorities about employment status of her UK assistant has no bearing on whether Heard is lying about abuse committed. Again, the idea once a liar, always a liar, maybe. The potential for prejudice far outweighs any potential relevance. Fourth, at deposition, Mr. Depp cross-examined Miss Heard's sister, but never questioned Miss Heard respecting Miss Heard's juvenile driving record, including driving on a suspended license in Texas while she was a teenager. These driving violations were while Miss Heard was a minor, and even then are neither felonies nor misdemeanors involving moral turpitude. And even the convictions could be elicited, which they cannot. In no event may the details be elicited. Such evidence could also be excluded as irrelevant to the issues at trial. Whether Miss Heard had speeding tickets as a minor and drove on a suspended license as a minor have no bearing on whether Miss Heard is lying about Mr. Depp committing domestic abuse of her, and prejudice far outweighs any potential relevance. So, yeah, she drives without a license sometimes. Fifth, at deposition, Mr. Depp also cross-examined Whitney, suggesting her sister was driving the vehicle at the time of the tragic death of Miss Heard's close friend Logan when they were both teenagers. The suggestion was made even though there's not a stitch of evidence to support this outrageous allegation. Miss Heard was nowhere near the county in which the accident occurred at the time and was devastated when notified. There's no evidence whatsoever, let alone any charges or conviction, that Miss Heard had anything to do with this tragic death. Such evidence should also be excluded as relevant to the issues at the trial, and even the malicious suggestion that Heard was driving at the time of the incident should be excluded from trial. 6, for the same reason, Mr. Depp should be precluded from claiming or suggesting to the jury by any means that Heard has a criminal record. Depp's counsel has repeatedly made such assertions during various court hearings, in third-party depositions, and even meet and confers, regardless of the relevance to each proceeding, and Ms. Heard expects counsel to do the same in the presence of the jury, absent this court's intervention. Such prejudicial statements and references should also be excluded for all the reasons set forth above, and any possible relevance is far outweighed by potential prejudice to the jury of such allegations and accusations. As noted above, all above evidence should be further excluded because probative value of such evidence is substantially outweighed by danger of unfair prejudice and likelihood of confusion of the jury. For the same reason, the trial exhibit should also be excluded. Okay. Evidence of Amber Heard's pledges and donations to charities should be excluded. I bet they would want those excluded. That would be fun. At virtually every hearing and deposition, counsel for Mr. Depp has adamantly pronounced that Heard is a liar because she says she donated the $7 million she received from divorce proceedings to charity, and she has not, and she has deprived children with cancer and needing surgery. I mean, a little bit, yes. The reality is Miss Heard has been responsible for donations of roughly $1 million to charity, has been responsible for is interpretable so many different ways, and fully intends to comply with her pledges to both. But because she was sued by Depp in this lawsuit, she's been unable to fulfill. Why is her being sued by Depp a problem? She had all the money for 13 months before she was ever sued. Why is her being sued a problem? She should have made those donations long ago. Significantly, this has nothing to do with whether Mr. Depp abused Miss Heard. It is the linchpin of virtually every effort in this court and third-party depositions and the press to discredit Heard and suggest that she has not yet fulfilled the entire amount of pledges. She's a liar, and therefore the jury should conclude that she lied about not yet paying all $3.5 million pledged to the hospital. She must be lying about Depp abusing her. Again, if you're a liar in one thing, it might suggest you're a liar in other things. This is precisely the type of collateral issue that should be excluded under the Virginia rules as completely irrelevant and likely to cause significant prejudice and confusion to the jury. Information related to Miss Heard's pledge to donate $7 million, the proceeds of a divorce settlement to charity, does not make it more or less probable that Mr. Depp domestically abused her. Mr. Depp has testified the settlement proceeds have nothing to do with any claims of abuse by Miss Heard. None of the $7 million that Miss Heard was rewarded for in divorce has anything whatsoever to do with any of her claims. Any of that, no. There's not even remotely a nexus between her donation and any claims, either by Depp or Heard in this case, and there's no mention of the donations in any pleading. While Depp has argued in the UK proceeding that Heard's allegations were motivated by an insurance policy and to build a dossier, neither of which relates to the $7 million pledge to charity, Miss Heard's sole motivation for claiming abuse, as alleged, is in this litigation is to further her career. There's absolutely no allegation by Depp that Heard's settlement proceeds had anything to do with allegations of abuse, and as noted above, Depp specifically denied the $7 million payment to Heard had anything to do with the allegations of abuse. Miss Heard's announcement that she'd be donating the money to the ACLU and Children's Hospital was more than 2 years prior to the publication of the op-ed. And contrary to Depp's common refrain, she has never tied her donations to her motivations for alleging abuse, the idea of which is risible. Ooh, it's a risible. It gives a rise. It's a risible. I am kerfumped. I am shocked and appalled. Shocked and chagrined. It's given rise to me. This idea is so contemptible. Shocked and chagrined. Even if the court deems evidence of Miss Heard's donation somehow relevant, it might be a little bit relevant to her integrity, I would think. Mr. Depp should be precluded from offering it, as its probative value would be greatly outweighed by dangers of unfair prejudice and likelihood of confusion. I don't know. I think the jury is going to learn that she's a liar, and it's going to go a lot to her credibility, I think. Mr. Depp has raised the issue of donations on countless occasions before this court in dramatic fashion that Miss Heard lied about donating to kids with cancer. She may have lied about donating to the kids with cancer, yes. Yeah. Mr. Depp commonly repeats suggestion that Heard is abandoning sick children would serve no purpose other than significantly prejudicing a jury. Well, she's the one that abandoned the sick children. She could just not do that. Further, the details of multiple transactions pertaining to donations, including transactions from donor-advised funds, how they're classified and credited towards her pledges, and the legal impact of signing a pledge form, which incidentally I don't think she signed, are complex and require legal expertise, and will create a confusing sideshow that will distract from already complicated issues at this case. Moreover, Depp is not designated expert for the topic, the expert of she didn't pay the money. I mean, how much expertise do you need? In addition, Depp has repeatedly attempted to tie Elon Musk to donation issues, as well as frivolously suggesting he's been paying for her attorney fees, when not asserting the ACLU is paying for attorney fees, but this court has already ruled there's no relevance to the anonymous donation. Such references or suggestions would only serve as prejudicial to Ms. Heard and not probative of any element of the claim. All evidence pertaining to the claim must be excluded and should be precluded from referencing the donations. I bet you would have liked that very, very much, because you are a completely insane person. Yeah. Yeah, risable, laughable. It gives a rise to you. Yeah, it's ridiculous, absurd. Exactly, you got it. Yeah, risable is laughable. It's absurd. I can't believe it. Shocked and chagrined. It's so silly. It's so ridiculous. It gives a rise to me. I am risen, sir. Yes, you got it. You're right. Yeah, you got it. Yeah. Evidence of Mr. Depp's charitable donations, including but not limited to any monetary or in-kind donations and donations in time, any photographs of Depp at any hospitals, direct like Jack Sparrow, should be excluded. Yeah, heaven forbid we show that Johnny Depp actually cares about the sick concert children, and you don't. Right. This court, at a hearing from the motion to compel for the 11th and 12th requests for productions and documents. How many requested documents are there? Holy God. Denied the request, ruling that evidence of the donation to charitable organizations, whether monetary or donations of time, are irrelevant. Well, it goes to show Depp is a good person and not so much you, Amber Heard. Yeah. Risible? Okay. Maybe I'm pronouncing it wrong. Yeah, maybe I'm pronouncing it wrong. Maybe it is risible. I thought it was risible. Okay, well, either way. Fair enough. Miss Heard has sought documents identifying Mr. Depp's donations to any charitable organizations, including any document referring to any time given or donated by Depp to any charitable organization, if no monetary donation was involved. Depp took the position that Depp's charitable donations are totally irrelevant. Mr. Depp has never tied his charitable donations to this case, has never indicated he intends to present evidence about his own donations, and does not intend to do so. Based on his argument, the court denied the motion to compel. Depp has no legitimate reason to oppose the exclusion of this evidence since he's previously... Yeah, it doesn't matter. It's fine. Depp should be precluded from introducing any evidence on subjects of which attorney-client or work-client privilege was asserted. On a number of occasions, Depp has asserted attorney-client privilege and refused to permit discovery, including responses to questions in depositions. For example, in each of the defamatory statements at issue in Ms. Heard's counterclaims, Depp has refused to allow his attorney, Admin Waldman, to answer any questions regarding statements such as, did you make this statement on behalf of Mr. Depp? Why did you make the statement? Were you representing Depp at the time you made the statement? Did you discuss the statement with Depp before making the statement? Did you discuss the statements with Depp after making the statement? Was Depp aware either before or after that you were making the statement? Did you make the statement with the authorization or agreement? Was Depp aware you were speaking to the press? Did Depp ever speak to you, ever ask you to retract or correct the statement? And did you rely upon any statements or evidence from Depp in making the statements? Depp also refused to answer the same questions, because they're all protected by attorney-client privilege, you idiots. Depp also refused to allow his publicist to answer any questions respecting conversations she had with Waldman respecting the statements. That might be within the scope of the practice, so yeah. Excuse me. Mr. Depp also claims text messages between Heard and Stephen Deuters, Mr. Depp's assistant, were somehow fake. Yet Mr. Depp refused to allow Deuters to answer questions about whether Deuters had any basis to believe the texts were not authentic. Incredibly, Deuters was instructed not even answer a question about information other than what he learned about his attorney respecting the things at issue. Given that Depp has asserted privilege on these issues and refused to allow Heard's discovery, Depp must be precluded from asserting any legal argument or introducing any evidence relating to the matter. $4.99 from T in Tennessee. Hello, T in Tennessee. Glad to have you here. T in Tennessee is a major supporter of the channel, and we do appreciate major supporters of the channel. T in Tennessee kicks ass. Who says, is it my imagination? Or do I remember Amber Heard said he didn't give to charity? I don't recall that specific element, to be quite honest, but it would be kind of absurd because he obviously gave of himself to charity on more than a few occasions. So I don't remember whether or not she claimed that or not, but it would be absurd. Thank you very much. And by the way, T in Tennessee, that was really awesome of you yesterday in Law and Lumber's chat for all those membership donations that you gave. That was really, really cool of you. And I wanted to acknowledge you in chat, and also wanted to acknowledge that because that was really, really, really cool to see support of Rob. That was really, really awesome. So, awesome. Mr. Depp cannot use attorney-client privilege as both a sword and shield, which is contrary to its very purpose. As the Virginia Supreme Court has held, parties should not be permitted to use privilege as both sword and shield, preventing the omission of evidence and sword to mislead the finder of fact by allowing evidence it would be impeached by the privileged information and not been suppressed. Such a pick-and-choose approach may seem unfair in general, or because it distorts the evidence as presented to the facts. Fact finder. As a result of parties attempting to use these sword and shield tactics, many of these courts preclude a party from introducing evidence or testimony at trial that the opposing party was prevented from exploring during deposition by invoking attorney-client privilege. Yeah, I mean, if it's privileged, you can't even really allude to it. That would be prejudicial. That's true. The court barred plaintiff from introducing testimony at trial on issues the plaintiff had previously prevented the defendant from exploring during deposition by invoking attorney-client privilege, and explained that allowing the plaintiff to present the testimony at trial would allow the plaintiff to use the privilege as both sword and shield. In fact, the Eastern District of Virginia has held as much. Mr. Apologize. Mr. Depp has throughout used and continues to use attorney-client privilege as a shield to prevent discovery of relevant communication. As a result, he should be prohibited from referencing, introducing evidence or testimony mentioning at all any topic for which they have objected. Makes logical sense. Okay, then there's this issue dealing with using these other transcripts. I think I'll skip that issue. Dealing with the late discovery. Mr. Depp inappropriately... Okay, here we get into some salacious stuff, so this will be fun. Mr. Depp inappropriately seeks to introduce evidence of the following irrelevant personal matters. Nude pictures of Amber Heard, Amber Heard's sister's Whitney's reality show video, Whitney and Amber's past romantic relationships, and Amber's brief stint as an exotic dancer years before she met Mr. Depp, and Mr. Depp attempting to frivolously and maliciously suggest or imply that Miss Heard was at one time an escort. None of the irrelevant personal matters have any tendency to make any material fact more or less probable, including the fact of domestic abuse. Rather, any purported evidence of irrelevant personal matters would serve solely as a sex-related distraction and tangential publicity bombshell, which would confuse and prejudice the jury and could negatively affect Amber Heard's reputation as an actress. For example, first, nude photographs of Heard have no bearing on a material fact in dispute. $20 from Tracy Fagan. Thank you very much for your super chat. The fake punch was in Isaac's testimony about Amber Heard and Whitney Heard at the elevator. Thank you for that important clarification. Thank you for your super chat and your support, Tracy. It is very, very appreciated. Thank you. It helps the channel exist. Okay. For example, nude pictures of Amber Heard have no bearing on any material fact in dispute. They're irrelevant, very personal, and tend to inappropriately to objectify Amber Heard, which is demeaning and would definitely detract from the issues of this case, of whether Mr. Depp committed domestic abuse. Second, there's nothing about Amber's sister's Whitney's reality show video from high school that could shed any light on any material issue in this case, namely the relationship between Amber Heard and Depp. Third, whomever Amber or Whitney dated prior to 2011, before Amber Heard met Mr. Depp, is wholly irrelevant Amber and Whitney's prior romantic relationships are far removed in time and subject matter from this case. Fourth, allegations that Amber Heard was an escort are unfounded, incendiary, irrelevant, and designed to harass or demean Amber Heard. And Miss Heard's brief stint working as a strip club, just after moving to LA to start her acting career, has nothing to do with her relationship with Depp years earlier, or whether she abused her. Fun. In addition to being wholly irrelevant, evidence of irrelevant personal matters should be excluded because any probative value is substantially outweighed by dangers of unfair prejudice and/or likelihood of confusing or misleading the jury. Excuse me. 1 second. Okay. Evidence of irrelevant personal matters will likely distract the jury from critical domestic abuse issues, excite potentially irrational emotions, entice gossip and speculation on irrelevant matters, and lead to harassment, bias, and prejudice towards Amber Heard and her sister. For example, first, nude photos of Amber Heard or comments about her stripping or escort services would likely be highly distracting and unfairly prejudicial to the extent they portray Amber Heard as a sex symbol instead of a woman's rights activist against domestic abuse. I mean, why not both, I suppose, is one answer, but okay. Second, Amber Heard's sister but she doesn't want us to view her as a sex symbol? That's good, because I don't. I don't think she's an attractive person. So congratulations, you got what you wanted. I don't think you're attractive. Second, Amber Heard's sister alleged reality video is likely to confuse or mislead the jury by focusing on third-party relationships, not the relationship between Heard and Depp. The reality video likely would unfairly prejudice Amber by minimizing the grave domestic abuse allegations at issue. Third, Amber and Whitney's past relationships will be distracting and confusing because those relationships have no bearing on the issues of the relationship between Depp and Amber Heard, and any conflation of relationships would cause unfair prejudice. Fourth, post-separation alleged affairs likely would mislead and confuse the jury because affairs have no relevance to findings of domestic abuse. In addition, affairs would likely provoke negative emotional connections for at least some jurors, causing unfair prejudice. So we want to go into past affairs that she might have had? That'd be fun. In 2018, Miss Heard initiated an arbitration against Depp for comments he or his attorney had made to GQ and other print publications that never had abused Miss Heard. She had attacked him. Let me turn on the light a little bit. It's a little bit hurting my eyes. How much can I turn it down without compromising video quality? That'll do fine, I think. Maybe a little bit more. Okay. Damn, my eyes are having a sensitive day today. Okay, where was I? Ms. Heard initiated the arbitration pursuant to her divorce agreement with Depp. The arbitrator found the case was not arbitratable because he had not been appointed jail per term for continuing proceedings under the divorce agreement, and because the divorce agreement did not clearly and unmistakably confer upon him power to determine arbitrability. The arbiter did not decide any of the merits of the lawsuit in any way. Ms. Heard took no further action with respect to attempting to enforce the terms of the settlement agreement. Yet Depp's counsel made statements in court, $5 from the real Laura B. Excuse me. Amber sent those photos to Johnny, and he had to turn them over. The one audio Amber Heard claims that she was a stripper, JD angrily texts and calls her a whore. Well, okay. I mean, that's not great, but if it is what it is, then that's, this situation. But thank you for your super chat. Depp's counsel made statements in court and deposition and meet and confers, suggesting Miss Heard had brought a suit and lost, that Miss Heard had fired the first shot, that the arbitrator granted motion to dismiss, and suggesting Depp prevailed on the merits. Miss Heard moves the court to preclude Depp from referencing in any manner the arbitration proceeding, including eliciting testimony about arbitration, suggesting in a manner that Depp won the arbitration, characterizing the arbitration, that Amber filed the first shot, or anything else related to it. And that seemed to have all been excluded, yeah. Skip. The fact of the UK judgment against Depp is undeniably relevant to this case. I have a meeting in 30 minutes. Okay. So we'll have to end this stream and then resume the stream at some later time, because I have a meeting in 30 minutes. Let me see if I can reschedule. Hold on. Okay. In addition, the testimony of the witnesses in the UK and conduct of Depp in producing certain evidence in the UK will also be evidence at trial, is relevant, is introduced in an appropriate manner. But the parties should be precluded from characterizing, arguing, or eliciting testimony suggesting their own interpretations of what the court found, why it found it, or what evidence was, without proper evidentiary introduction of the document and supplied references. Okay. See if there's anything else in here that we want to claim. Okay. Throughout this litigation, Mr. Depp has attempted to pressure witnesses into testifying respecting Miss Heard's purported abuse of other individuals. Pressure? Like how? By asking questions? But there remains no admissible evidence supporting Mr. Depp's desperate claims that Heard ever abused any other individuals. Mr. Depp has further attempted to inject the issue of his allegations. Miss Heard abused him, despite the content of the op-ed forming the basis of Depp's defamation claim being wholly distinct from any such allegation. First, this issue is not relevant to the core factual issue in both the complaint based on the op-ed and the counterclaim, where Depp abused Heard, and for the counterclaim, the other related factual matters, respecting whether Heard faked her injuries as Mr. Depp falsely contends. Mr. Depp even agreed, objecting that Heard seeking facts of each supposed incident, during which you contend Heard inflicted any type of physical or emotional abuse, was unlikely to lead to any discovery of admissible evidence, and seeks documents and communications that are relevant, immaterial, or unnecessary to the issues of the action. Second, Depp repeatedly attempted at deposition to pressure Whitney to falsely state that Heard hit her or threw objects at her, which Whitney has denied. Third, Depp has repeatedly referenced the arrest in the Seattle-Tacoma airport, but Tysa Van Ray herself, whom Miss Depp claims is the victim related to this arrest, has stated that Heard was wrongfully accused, and the charges were quickly dropped and released months later. Finally, all the above evidence should be further excluded because the probative value is outweighed. Throughout litigation, counsel for Mr. Depp has repeatedly asserted that besides Miss Heard, Mr. Depp has never been accused of domestic abuse by anyone. But counsel making such general statements is not evidence, and any such testimony would be hearsay and lacks foundation, is therefore inadmissible, and suggesting this would be significantly and unduly prejudicial in front of the jury and should be prohibited. For clarity, Miss Heard is not seeking to prohibit Depp from affirmatively questioning witnesses by asking if such witnesses have ever been abused by Mr. Depp, providing such questions otherwise comply with the rules of evidence. But counsel should be precluded from making such broad and generalized statements in the negative, or even eliciting testimony from Depp or anyone else as to whether he's ever been accused or committing abuse by anyone else, because such statement would necessarily rely on matters wholly outside the litigation, along with relying on hearsay and lacking foundation. Well, it's not hearsay. It's not hearsay. That doesn't even make sense. Hearsay is statements. Hearsay is statements. Somebody said something is hearsay, right? Johnny Depp said something, or Amber Heard said something, or a witness said something. It's statements, right? I've never abused anyone is not hearsay. It's not a statement. Or it's not a statement in that way. It's not him saying something. It's just making a claim, right? I never abused anybody. It's not hearsay. He's not referring to something. It's not an out-of-court statement. It's in court. He'd be saying it in court. I never abused anybody. It's not hearsay. What are you talking about, hearsay? Lacking foundation? What do you mean lacking foundation? He would know. What are you talking about? Foundation goes to how do you know a thing, right? How do you know? Bob hit Johnny at the Walmart. How do you know that? Were you there? Did you see it on a videotape? Did someone tell you? Did you have a fever dream? That's foundation. Johnny hit Bobby at the Walmart. Okay, how do you know that? What is your foundation for that? Foundation makes no sense here at all. Johnny Depp is testifying about things he did or not. His foundation is, I was there. I never hit anybody. What's your foundation for the statement? I was there at all the times I was not hitting somebody. This is hearsay. It's really not. 20 Canadian dollars from Jen CA. Just keep reading. I'm liking the background noise while I'm working. Well, let's see if this appointment can be shifted or not. I'll get back to you. I might have to do a part 2. But we'll see. But none of these objections make any sense. Hearsay and lack of foundation? What hearsay? What lack of foundation? The probative value of such evidence is also substantially outweighed by danger of unfair prejudice? No. How is it unfairly prejudicial? What? For these reasons, any evidence or testimony that Depp has never been accused of domestic violence should be excluded. No. This is dumb. This is really dumb. And it's easy for you, Amber Heard, because once he says it, you can impeach him on it, right? Even if it wouldn't be offered for any other reason, because it's not relevant. Once he says it on the stand, you may not be able to bring in prior instances of domestic violence for their substance, but you can bring them in for impeachment, at which point you don't care. Unless you're on the bar exam, in which case they care. An attorney would never really care. But, the bar exam cares. But if you're in the real world, you don't care, because once it's in, it's in. So once he says, I never abused anyone, you'd be saying, boy, oh boy, all I have to do is prove one time he did, and I can impeach him. Never happened. Okay. Ooh. Excuse me. The rule, okay. Johnny Depp's expert witnesses and their testimony should be excluded pursuant to the Crane Doctrine. The rules require a party to identify each person whom the other party expects to call as an expert at trial, to state the subject matter on which the expert is expected to testify, and state the substances of the facts and opinions on which the expert is expected to testify, and summary of a ground for each opinion. Mere disclosure of the topic of testimony is insufficient to satisfy the rule. Defendants' expert designations do not meet the requirement of the rule or Crane, and are rife with speculation. Conclusory generalizations seek to testify to ultimate issue and are without support that need to be provided in response to discovery. Expert testimony is inadmissible if speculative or founded on assumption that has no basis in fact. Okay. Mr. Depp has identified Richard Shaw as an expert to partially rebut Dr. David Spiegel's opinions regarding Depp. Dr. Shaw's opinion in his designation does not evaluate any evidence in this case. Rather, he opines that Spiegel cannot provide his opinion respecting Depp because Spiegel did not personally interview Depp, which Dr. Shaw opines is a violation of ethical rules in psychiatry called the Goldwater Rule. As described below, this rule is not applicable to litigation. It does not apply when a psychiatrist has access to medical records, which Dr. Spiegel reviewed. Dr. Shaw admits this opinion is thus based on the quality of the medical records in this case. Yet Dr. Shaw's designation is void of any commentary whatsoever respecting Depp's medical records. Therefore, Shaw's proposed testimony must be excluded based on Crane. According to the rules of the Virginia Supreme Court, expert testimony is admissible in a civil case where scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or dismiss the fact at issue. Here, Dr. Shaw is not offering any opinions that will assist the jury in understanding the evidence. Rather, Shaw describes psychiatric ethical rules called the Goldwater Rule and claims Dr. Spiegel failed to abide by the rule. But courts have held that the so-called Goldwater Rule, an ethical rule that appears to preclude psychiatrists from rendering opinions on the mental state of public figures, does not apply in this situation, at least not as a bar to testimony. Indeed, the Goldwater Rule has nothing to do with litigation, and Dr. Shaw's own disclosure states was developed following a controversy that emerged during the 1964 presidential election, when Fact magazine published the results of a large survey of psychiatrists who were asked whether Senator Barry Goldwater was psychologically fit to run for the presidency. The rule states that on occasion psychiatrists are asked for an opinion about an individual who's in the light of public attention, or has disclosed information about himself or herself through the public media. In such circumstances, a psychiatrist may share with the public his or her expertise about psychiatry issues in general. However, it is unethical for a psychiatrist to offer a professional opinion unless he or she has conducted an examination and been given proper authorization for such a statement. This rule does not say anything about prohibiting expert testimony. In fact, the Ethics Committee of the American Psychiatric Association commented on the rule and stated it's ethical for a psychiatrist to testify about competency of a defendant based on medical records, and not examination of the defendant. The Ethics Committee has also found that experts are allowed to render an opinion in court without in-person exam because there's court authorization for the examination or opinion without examination, and the work is conducted within an evaluative framework, including parameters for how and whether information may be used and disseminated. In this case, while Dr. Spiegel did not interview Depp, even though he asked to interview Depp twice, Dr. Spiegel reviewed video of Depp's 3.5 days of deposition testimony from all of Depp's doctors, testimony from other witnesses, audio recordings, video recordings, emails, text messages, and medical records. And also, he watched the Pirates of the Caribbean movies, as we learned during testimony, which was a fun little moment. Dr. Shaw also admitted in deposition that it's reasonable to render an opinion on such a record. I do think it's reasonable to render opinions about a case based on review of medical records if the medical records are of good quality and rigorous and meet the standards of care. So Dr. Shaw's entire opinion about the Goldwater Rule applying to Dr. Spiegel in this matter is reliant on Dr. Shaw's opinion about the quality of medical records, but Dr. Shaw's designation is completely devoid of any discussion of the medical records in this case, which Dr. Shaw admits. Dr. Shaw also opines about the deposition of Depp, stating it was a long deposition in which it was difficult for him and exposing, and which he frequently interrupted, and was told he was not answering the questions appropriately, and which there were arguments between the attorneys was upsetting to him. And knowing what we know about the history of exposure to trauma in his past, this is clearly upsetting to him. And so I think relying on that deposition was not proper and not necessarily representative of who Depp is. But just like the medical records, Mr. Depp failed to reveal in his expert disclosure anything Dr. Shaw would be opining about the deposition. In Crane, the Virginia Supreme Court ruled on disclosure requirements of the rules. The court held that where Crane failed to reveal his proposed expert might testify about asbestos in the ambient air, the trial court properly excluded that proposed testimony from evidence. A party is not relieved from disclosure obligation under the rule simply because the other party has some familiarity with the expert witness or the opportunity to depose. Therefore, even though Dr. Shaw revealed in his deposition he planned to testify about the quantity of medical records and Depp's deposition testimony, because he admits the material is not his disclosure, the testimony cannot be admitted. And given that the opinion respecting whether Goldwater Rule applies in this matter is entirely dependent on records, Dr. Shaw must be excluded from testifying at trial. Okay. In Mr. Depp's list of witnesses for trial, he discloses that he may call his personal physician, Dr. David Kipper, whom he's paid millions of dollars, for live testimony via video link at trial. If Mr. Kip is called as witness, he may only testify as a fact witness, and be excluded from offering any expert opinion, as both Depp and Kipper prevent discovery, based on the representation that Kipper will not provide expert testimony in this matter. Okay. On February the 16th of 2021, Dr. Kipper was originally designated as a non-retained expert for Depp, who was expected to testify as to pharmacological effects of medications of prescriptions of Depp, as well as medical opinions reached during the course of Depp's and Heard's treatment. In doing so, Kipper may rely on his expertise and experience as a medical doctor practicing internal medicine. Yet just days later, as deposition, Kipper refused to answer any questions that called for expertise, with his counsel stating, "I will instruct you not to answer any questions calling for expertise." Based on that instruction, Dr. Kipper refused to answer questions such as what drugs Depp was addicted to, whether Depp was erratic while attempting to detox from the drugs, Dr. Kipper's basis for believing that Depp romanticized the entire drug culture, why it was best for her to be away from Depp after she told Kipper that Depp had pushed her during his attempted detox, Dr. Kipper's concern about Depp's hallucinations, whether Depp experienced drug relapses, whether Depp was coherent after Depp chopped off his finger, and the purpose of prescribing particular drugs to Depp, and whether Kipper was concerned about abuse to Heard. $2 from Q Squared. 830 watching, only 400 likes. Let's get them up. Well, thank you, Q Squared, for encouraging people to hit that beautiful like button. Also, as a friendly reminder, if the subscribe button on your screen is currently red, the subscribe button is feeling angry and disquieted. It is feeling unsure and feeling animus to the world. But it doesn't want to feel this way, my friends, and you can help. By merely clicking the red subscribe button, it will become a calm, integrated, peaceful, at one with itself gray button. It will achieve enlightenment and nirvana that we all seek to achieve. And you can be the change merely by clicking that red subscribe button and making it gray. The gray subscribe button will become an integrated, peaceful subscribe button. So click that red subscribe button today. In addition, in order to prevent Heard's expert Spiegel from taking a medical exam of Depp after disclosing Kipper as a potential expert, Depp's counsel backtracked and represented to the court we're not proffering Dr. Kipper as an expert on anything, we're proffering him as a fact witness. Okay. Thus, if Dr. Kipper is to testify, it must only be as a fact witness, and he must be prevented from testifying as an expert and on subjects which he's previously refused to testify. And as explained below, Mr. Depp improperly double designated Kipper to testify both by designation and reserving the right to call by video link. Yeah. Therefore, and yes, hitting the subscribe button also allows you to chat. Allows you to participate in the chat. The best subscribe pitch I've ever heard, it is an original. I wrote that subscribe pitch. That is an Uncivil Law original. And I look forward to it being copied and emulated by other subscribers in the future. Or other people in the future, but thank you. Thank you. It's like, yeah, we got to find a way to pitch the subscribe button, help the subscribe button be at peace with itself. It's what you'd want. Click the subscribe button today. Yeah, I think it's pretty good. Plaintiff identified Jack Wigham, Christian Carno, Edward White, and Robin Brom as non-retained experts. These non-retained experts were not included in the supplemental designation, plaintiff has made no indication since 2021 that he intends to rely on these fact witnesses as non-retained experts. So it appears plaintiff does not intend to rely on those fact witnesses as non-retained experts. However, out of abundance of caution, Heard files this motion in limine. Depp should be precluded from relying on these individuals as experts in any manner because he's not identified them in his designation. In addition, the non-retained expert designations do not meet the requirements of the rules. The 3-sentence designations for each non-retained expert contain only disclosure of the topic testimony and state no facts or basis for their opinion. Yeah, that makes total logical sense. As of the date of following the motion, Mr. Newmister has not served any supplemental expert disclosure, and expert disclosures to date fall well short of the Crane standards. Thank you. Excuse me. Miss Heard has diligently pursued a date when Mr. Newmister will produce this supplemental disclosure, and Depp even committed to identifying the date by March 18th, but then Depp failed to do so, and continues to fail to do so at the date of this filing despite further attempts to resolve the issue. Therefore, Heard moves to exclude it on that basis. All right. Dr. Curry. Why are we trying to keep Dr. Curry out? Because she's, relatable. She's fantastic as an expert witness. She's really, really good at her job. You wish you had her as an expert, but you don't. Yeah. Deep diver, I honestly don't know where that part is. I'm trying to review. There's 6,600 pages of documents, deep diver. I don't know where everything is. If you happen to know, let me know. Let's see. Dr. Curry's deposition was taken on March 21st, 2022. During deposition, Dr. Curry admitted that she did not evaluate and was unable to provide an opinion as to whether Depp abused or did not abuse Heard, whether Heard abused or did not abuse Depp, and she did not evaluate and was unable to provide an opinion as to whether Heard suffered any emotional distress as a result of 3 defamatory statements made by Waldman that are subject to the counterclaim. Dr. Curry should therefore be excluded from testifying on these subjects. In addition, Dr. Curry repeatedly referred to Rule 410 examination as an independent medical exam, and that her exam of Heard was court-ordered. It kind of was. Each of these references was designed to suggest Dr. Curry was testifying on behalf of the court, and that Ms. Heard resisted the Rule 410 examination, both of which are false. The court has not appointed Dr. Curry as an independent examiner on behalf of the court, and Ms. Heard did not object to providing a Rule 410 examination. Her position was simply that it should be ordered for both parties, which the court disagreed, because it shouldn't be offered for both parties because it's not relevant as to him. Even if Heard had resisted or opposed the 410 examination, like any other opposition to a motion to compel, the fact of opposition is not relevant and would be unfairly prejudicial, confusing, and misleading to the jury. Excuse me. Who risks inferring that Miss Heard, apologize. That's just a complete misread on that one. Wow. Who risk inferring that Miss Heard has done something wrong, resulting in the court ordering her to be examined as an independent expert. As discussed in greater detail, but broader request is being asked here, the use of the term independent is misleading and unfairly prejudicial, and references to court-ordered examination or that which was opposed. Dr. Curry, whose initial designation opined that Miss Heard was lying and abused Depp, is far from independent. She was hired by Depp's counsel and even had dinner or drinks at Depp's home. Finally, when asked about obtaining collateral interviews for verification and as best practices and continuing an examination and rendering opinions, Dr. Curry contended this court has ordered Dr. Curry not to engage collateral sources, citing to October the 8th, 2022 order. In fact, the language from the order, drafted by counsel for plaintiff, was stricken by the court because it could have been read to require third parties to speak with Dr. Curry, which was outside the purview of the rules. It did not prohibit Dr. Curry from reaching out to collateral sources or obtaining their records. In fact, Dr. Curry obtained 2 depositions of collateral sources, Dr. Cohen and Dr. Banks, yet did not include any aspects of their depositions in her report or supplement them. In addition, Dr. Curry was provided with Dr. Hughes' notes after a mutual order was entered and did not include those reports. Am I still doing this interview? This thing? I might have to take 5 or 10 minutes. The question is, do I kill the stream completely or do I see how long it lasts? This is because I've got 800 people watching. This is like one of the reasons I'm trying to figure this out right now. Let me finish this paragraph while I'm thinking. The paragraph above makes clear Dr. Curry was not limited to Dr. Hughes' report. Further, the rule provides that relevant records must be obtained as far back as necessary for Dr. Curry to determine, with a reasonable degree of certainty, how Heard was functioning prior to an alleged traumatic event, but not fewer than 3 to 5 years prior to the alleged trauma. Indicate Dr. Curry can assess any number of areas, including any other mental condition identified by Curry during review of relevant records and or examination of Heard. The defendant therefore requests that Dr. Curry be prohibited from testifying from the court or relying on collateral sources of her opinions. Okay. Stop and come back. Yeah, I think that's probably the cleanest way to do it. I think that's the cleanest way to do it. So I think we'll do it that way. Yeah. So, yes. Have I tried Flonase? Yes, I use Flonase every single day. I use Claritin and Flonase every single day. Yes. With that in mind, I will thank you very much for your participation and your watching. If you've not already done so, please remember to do the YouTubey things. Have you considered hitting the like button? There are only 487 likes, yet 838 of you. I sense that there could be 400 more likes. Why aren't you hitting the like button? The like button is lonely and wants to be your friend. The like button currently is hollow inside. It is a hollow like button. If you click the like button, it will glow with white to represent its illuminating brightness, shining into the world. Help it be the light shining into the world. And have you taken a look at the red subscribe button? It's angry. It's angry because it feels so unloved, and it's currently plotting revenge and hate, but you can help stop it merely by clicking that red subscribe button. It's so easy, and it soothes the red subscribe button. It will become a nice, peaceful, calm, integrated member of society subscribe button. So click that red subscribe button today. And did you know for a mere 99 cents, you can become an uncivilian? It's true. You see these names at the top of the screen. You see these names right here, and you think to yourself, what are these names scrolling at the top of the screen? What is an uncivilian? Who are these magical people? Well, it could be you, my friend. You could be one of the magical people. All you have to do is hit that join button, and if you're on an iOS device and you don't see a join button, no problem. From time to time, the bot is providing you a link that you can click on, and that will help you join. And if you click that link, you will become an uncivilian. For a mere 99 cents, it's literally the least YouTube will let me charge you. You can become an uncivilian, and you get your name up here, and you get a cool little scale of icon. You scale to justice icon by your name. And also, you get to secretly look down on everyone else who doesn't have the cool icon by their name, and you get to know in your own heart that you are better than them because you have become an uncivilian and achieved the ranks of glory. So make sure to do all those YouTubey things. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.